There's also a loan modification, which obviously you can talk to Chris with in detail about a loan modification. But right now, we're not seeing the banks really typically forgive any type of principal. So a lot of people, a lot of clients will come in to me and say, hey, I need them to forgive principal. The banks just right now, they're not doing it. For a lot of people, a loan modification works. They really love their home. They want to stay in their home. And basically what happens is you can get a kind of a lower rate, 3.2 to 4% type of introductory rate, which for a lot of clients works. Now, it's important to know the difference between your primary and your investment property. If it is a primary residence, you're going to qualify for the Making Home Affordable program. If it's an investment property, you are not. So that's going to be very pertinent to whether or not you're going to get a decent loan modification. Now, the most common and the best settlement that we're seeing right now is what's called a short sale. Basically, with the short sale, hopefully we get the posture of the case to where, they're having a difficult time foreclosing on you, and you'll list the property with a realtor just like you would in the past. And basically that real estate agent will come to us with a contract. You'll have to provide additional financials. And then it's up to the lender to accept the short sale. Now, the language in the short sale approval is very, very important. You want that short sale approval to somehow signal that there will be no deficiency against you, that there will be a zero balance against you. Satisfaction of mortgage does not work. Satisfaction of mortgage means they satisfy the mortgage, not the note. So it's very, very important to look at the language, and that's why I highly recommend that you seek legal counsel, not a real estate agent, to look over your short sale approval letter. Real quick, to jump into the problems, I know everyone's reading the front page of the paper. Everyone probably has heard of the Big Four, which is Stern's office, Marshall C. Watson, Florida Default Law Group, and Shapiro's Law Firm. Stern's office has been in the news statewide and obviously nationally. Basically, he's hired just regular employees, not lawyers, to basically sign and notarize assignment of mortgages. And what they were trying to do was to basically fraudulently create assignments of mortgages to take place before the complaint was filed, which is a standing issue. And obviously this is fraud on the court and just fraud in general. So we have a lot of cases with Stern's office. I probably have I'd say 20 to 25% of my cases with Stern's office, and as of right now, they're kind of at a halt. They're not really moving forward on a lot of the cases. So I look for them to possibly even switch counsel, midway through this process. Real quick, just to talk about the bank moratoriums. A lot of people are asking me about, hey, what's going on with the banks? It's my understanding that they've stopped the foreclosure process. Well, they did for about 10 to 15 days. And it's important to know the difference between the banks and their particular issues. GMAC, they have actually had a halt on foreclosures for the last month and a half, I'd say. What the GMAC issue is basically they were actually foreclosing on homes where they didn't have the right to foreclose. They didn't have the notes. So their situation was a lot more serious than Bank of America, JP Morgan, and PNC Financial. Those situations are basically, I know everyone's probably heard of what's called a robo-signing, where basically when they file their motion for summary judgment, they have to also assert to that with an affidavit to amounts due and owing. And what they would do is have employees with titles of assistant secretaries, vice president of loan docs, basically sign these affidavits to amount owed, swearing that there's no material issue at fact. And if you're not an attorney here listening, you probably don't know what a material issue of fact is. And to be honest with you, the people signing these documents didn't know either. And they swore to personal knowledge of what's on these documents. And obviously, there's no way for them to have personal knowledge of all the 500 documents or 500 affidavits they signed in that particular day. But nevertheless, Bank of America has lifted that moratorium, and they are moving forward. But to an attorney that's worth their salt, that doesn't mean much. When I go into hearings now, when I go into court, I'm going to tell the judge, and hopefully the judge agrees, that I have a hard time with that reviewing 100 to 200 cases and you saying that it fits your criteria to move forward, well, that's just not good enough for me. So good attorneys are going to ask to basically depose the corporate representative or the particular representative that signed that affidavit and get to the bottom of that. And just real quick, things are changing for the better for the consumer. We have mandatory mediation right now, which is great for modifications, and that's for Hillsborough County, Pinellas, and Pasco. The case law is favoring us. Judges, when I go in there, to me, I feel like they're predisposed to try to help the consumer stay in their home. Even lawmakers on the Hill, the Senate Majority Leader and the Speaker of the House is actually calling for a moratorium on all foreclosures right now. I don't know how far they'll get with that, but things are changing for the better for consumers, I think. Real quick to touch on the HOA, your homeowners association. If you're in foreclosure or you're about to go into foreclosure, we litigate these cases for a year and a half in a lot of situations. So your HOA is actually more powerful than the bank as far as foreclosure. They basically sue on the covenants. That we don't have all those juicy affirmative defenses that we have against the banks when you're dealing with the HOA. Basically, you sign those covenants, and those covenants say, hey, if I don't pay my HOA dues, you can foreclose on me. So I recommend, if the HOA, you can afford it while we're litigating the case, to pay that HOA. One more quick thing to talk about, too. A lot of people here probably have first and second mortgages. Well, obviously, your second mortgage, probably the equity is gone, and the second mortgage is really standing there with nothing. So what they're doing now is pretty crafty. They're suing in a breach of contract claim. And basically that means they're not suing to foreclose on you. They're just suing you on the contract, which is the note. And basically what that means is they're just going to try to get a judgment against you for that amount. So say you had a $80,000 line of credit or second mortgage tied to your property. They're just going to sue you for that balance. And what happens when they get that judgment is then they can start garnishing your bank accounts, garnishing your wages if you're not head of household. So it's a serious thing right now. What I've been doing, I've been basically moving to consolidate the cases if there's a first and second mortgage claim and one suing in a breach of contract, and I was successful in doing that last month. So real quick on our costs too, we do not bill you by the hour or anything like that. Basically our fees, it's a straight transaction fee. If you've just been served a summons and complaint and you're within that 20 or 30 days, typically we charge around $1,900 to $2,000, and then we have a monthly maintenance fee of around $175. There's no hourly billing. I don't bill you when I go to court or anything like that. The only other costs you have are when we mail out little incidentals in the office. But that's basically just a real quick rundown and a broad stroke of what we do here. Please, it's a great idea to sit down and talk with Chris if you can to get just kind of a feel for what's going on with your particular situation. If you've been served a summons and complaint, however, you need to get to an attorney, whether it's me or somebody else, immediately. That being said, I appreciate your time, and I'm going to pass you back over to Chris.
Thank you, Michael. I appreciate it very much. And again, before I forget here, again, Michael Owen, you guys can see, obviously, his website on your screen. But if you're on by phone, the firm's name is Christmas in Spano, PA. Their website address is www.christmas in Spano, just like the season, the holiday, christmasandspano.com. Phone number is 813-902-3897. That being said, I want to go ahead and open up the session. I do have everybody on mute right now, but I do want to, I do have a couple text-in questions here. So what I'm going to have to do is, and we're going to kind of have a joint answer question on this one. So with that being said, I'm going to go ahead and start with answering the text questions first. So the first one that came in was first, how long can I stay in my home with your services if in foreclosure? And I guess that seems pretty geared towards Michael, so I'm going to let him answer that one.
Yeah, and that's a great question. Really, it depends on the law firm and the bank. If they have all their ducks in a row, it's still going to take them quite a bit of time. You're probably still looking at probably around 8 months, even if they hired a smaller firm and not one of the bigger four that I spoke about earlier. That being said, I have a lot of cases where we've been litigating for close to 2 years, around 2 years, and it looks like it's going to keep going. So I would say a safe bet is that if we file an answer and then we file discovery, they're most likely going to file an enlargement of time to answer that. You're looking at anywhere from 7 months to 2 years for us to litigate the case, unless, of course, we get a settlement. Chris could get you a short sale and come to me within the first few months, and if it looks good, obviously I would tell you to settle the case. But in a lot of cases, the majority of the cases, you're looking at somewhere from 7 months to even 2 years in some cases if the bank's lost all the original documents.
And just to add on to that, what Mike was saying is that, if we're working, if one of my clients is working with me and we get the pleasure of working on a client when they're still current on the mortgage, and if they decide that they can no longer meet the obligations of the debt, and we're working on settlement from the whole time, sometimes it might be even, I've had a client where it's only been like a 2 or 3 month process before we had a legitimate settlement offer. So it was a very short defense duration for the law firm and for the client, but it was smart to get the answers and defenses into the court. So that being said, the time frame, I'm going to leave that up to him, but my average time frame for a client is, I would say, 6 to 8 months that with Hope for Homers Consulting. So